If the Supreme Court takes no Second Amendment cases this year, that choice will quietly shape gun law in the United States far more than most headline-grabbing decisions. Silence from the court is often misunderstood as neutrality, but in constitutional law, silence is rarely neutral. When the Supreme Court declines to act, it does not freeze the legal landscape. Instead, it allows existing trends to continue unchecked, and in many cases, those trends are moving in only one direction. The Supreme Court sits at the top of the judicial system not just to resolve disputes, but to enforce uniformity. When lower courts disagree on how to apply constitutional rights, the court's role is to step in and clarify the rules. When it does not, fragmentation becomes the default. Different regions interpret the same constitutional text in radically different ways, and those interpretations harden into local norms. This is especially important for the Second Amendment because gun rights litigation does not move quickly. Challenges take years, appeals take years. Emergency relief is rare and often temporary. When the Supreme Court chooses not to hear cases, it is effectively choosing to let lower courts control the pace and substance of Second Amendment enforcement. The Bruen decision was meant to bring clarity. It rejected interest balancing and replaced it with a historical test. But Bruen did not eliminate discretion. It shifted where discretion lives. Instead of weighing public safety against individual rights, courts now argue over history. And history, when filtered through selective framing, can be molded to support almost any outcome. Without new guidance from the Supreme Court, lower courts become laboratories. Some apply Bruen faithfully, others reinterpret it narrowly, some openly resist its implications. Over time, those resistant rulings accumulate, and they begin to shape the law more than the Supreme Court's original intent. States are keenly aware of this dynamic. When the court declines to take gun cases, states understand that enforcement risk drops dramatically. Even if a law is constitutionally questionable, the odds of immediate correction shrink. States can enforce restrictive laws knowing that litigation will take years, and that relief, if it comes at all, will likely arrive after the political or regulatory objective has already been achieved. This creates a perverse incentive structure. States are rewarded for delay. Even losing in court can be a strategic win if enforcement continues during appeals. From the state's perspective, time is leverage. From the citizen's perspective, time is the denial of a right. The Supreme Court's silence also affects how lower courts interpret their own authority. Judges are acutely aware of the court's docket. When the court repeatedly declines to hear Second Amendment cases, lower courts infer that aggressive interpretations are unlikely to be reviewed. This encourages experimentation at the edges of the doctrine. In practical terms, that means courts can narrow the scope of the right, redefine what counts as protected conduct, or invent historical analogs that justify modern regulations. Each decision may appear modest on its own, but collectively they reshape the right in practice. The absence of Supreme Court review also emboldens procedural tactics that blunt constitutional victories. Even when courts rule in favor of gun owners, enforcement is often stayed pending appeal. These stays can last years. During that time, the challenge law remains in effect, and the ruling exists only on paper. For individuals, this means that winning a case does not necessarily restore a right. It means entering a new phase of litigation where the right remains suspended. The Supreme Court's refusal to intervene at this stage effectively endorses delay as a governing principle. Silence also influences how future cases are litigated. Lawyers adjust strategy based on signals from the court. When the court shows reluctance to hear gun cases, litigants may narrow arguments, avoid certain claims, or focus on procedural wins rather than substantive rulings. Over time, this reshapes the legal conversation itself. Another consequence of inaction is the normalization of noncompliance. When lower courts repeatedly evade or reinterpret Supreme Court precedent without consequence, it signals that precedent is flexible rather than binding. This weakens not just the Second Amendment, but the authority of the court itself. The court's silence also interacts with political cycles. Gun laws are often passed in response to events, not long-term policy planning. When the Supreme Court does not intervene, those reactive laws remain in force long enough to shape behavior, markets, and enforcement norms. Even if they are eventually struck down, the damage is already done. This creates a ratchet effect. Restrictions are imposed quickly, relief comes slowly, if at all. Each cycle leaves the baseline more restrictive than before. Supreme Court silence accelerates this process by removing the final corrective mechanism. It is important to understand that the Supreme Court does not need to rule in favor of gun owners in every case to change this dynamic. It only needs to enforce its own standard consistently, taking cases, clarifying doctrine, and reversing lower courts that defy precedent sends a powerful signal. Declining to do so sends the opposite signal. Historically, constitutional rights do not erode through dramatic reversals alone. They erode through neglect. When enforcement weakens, rights become conditional. They depend on geography, judicial temperament, and procedural happenstance. Silence allows this erosion to occur quietly. For the public, this process is largely invisible. Most people do not follow certiorari decisions. They see only outcomes in their own state. This obscures the national pattern until it is deeply entrenched. By the time the Supreme Court finally intervenes, the legal terrain may be unrecognizable. Years of lower court decisions will have created a dense web of precedent, making correction slower and more complex. Silence today multiplies the cost of action tomorrow. There is also an institutional cost. When the Supreme Court avoids contentious areas, it invites lower courts to fill the vacuum. Over time, this shifts power downward. District and circuit courts become the real arbiters of constitutional meaning, while the Supreme Court becomes a distant reference point rather than an active enforcer. This is why doing nothing is not a neutral act. It is a choice that shapes incentives, behavior, and outcomes across the entire legal system. For the Second Amendment, where enforcement already lags behind doctrine, silence compounds existing weaknesses. The long-term effect is a constitutional right that exists in theory, but not uniformly in practice. People in one state experience one version of the Second Amendment. People in another state experience something entirely different. The promise of equal protection under the law erodes. When the Supreme Court eventually does act, it may find itself confronting not isolated errors, but a system that has adapted to operate without it. Reasserting authority at that point becomes far more difficult. In this sense, the most consequential Second Amendment decision of any given year may not be a ruling at all. It may be the quiet decision to stay out of the fight, to let lower courts define the boundaries, and to allow delay to function as policy. Silence is not the absence of power. It is the exercise of power through restraint. And in the context of gun rights, that restraint carries consequences that extend far beyond any single case.